Now, John Sauer, the Solicitor General, which I generally like this guy, I think he's done a pretty good job in a lot of these arguments. He was arguing on behalf of the executive order for Trump about ending birthright citizenship. His argument includes the whole sentence of the 14th Amendment. I know, weird. Including and subject to the jurisdiction thereof. This should have been like the end of the argument because of the examples I just mentioned. But Clarence Thomas, actually, he threw a wrench in everything and made, I think, the most salient point that I hadn't even thought of, which is, does the 14th Amendment even apply at all to illegal immigration?
How much of the debates around the 14th Amendment had anything to do with immigration?
This is why I love Clarence Thomas, because he always, without fail, interprets the Constitution with the intent as it was written at the time. And I was like, when he said that, I was like, wow, how many people were illegally immigrating to the United States after the Civil War? And John Sauer had potentially the best answer of the day regarding this issue.
There is a general principle, that's a broad principle that's adopted in the phrase subject to the jurisdiction thereof, and we submit that our theory of allegiance and domicile-based allegiance is what explains those specific exceptions that everybody was aware of, but it is broad enough to sweep in future situations, and as you pointed out, illegal immigration did not exist then. Now, the problem of temporary visitors did exist, and it's very interesting that as you look at pages 26 and 28 of our brief, commentators going from 1881 until 1922 are uniformly saying the children of temporary visitors are not included.
Boom. They're not included. So historical precedent appears to show that the very constitutional provision that the ACLU is using to make their argument may not even apply at all to illegal immigrants, which would leave Donald Trump's executive order barring birthright citizenship from illegal immigrants completely constitutional. And he would win, which he's won most of these. But I think a point that did not get enough of the spotlight today is the legal precedent of Maslanjak versus the United States from recently, 2017, where the Supreme Court, in a majority opinion, ironically delivered by the liberal Justice Kagan, held that the government can revoke citizenship when there's a material fraud in obtaining that citizenship. So wouldn't fraud in immigration be equal to coming here illegally? Like, I would imagine they carry the same legal weight. So my question to the ACLU and to the Supreme Court, that same court with some of the same sitting members hearing that case today, because that was only decided back in 2017, if they ruled that lying can get your citizenship revoked, why would they not apply the same legal standard to coming here illegally? And why should the product of that legality or illegality yield a child's citizenship under the illegal pretense of it? To use the term of the day, domicile. The argument was convoluted. It was legalese, which is what lawyers do. But the root point, you can't reward somebody and give them something so precious as U.S. citizenship if they broke the law to get here.
He loves the Constitution. He fights for what's right. He hates the bad guys. He's a freedom warrior. He's your freedom warrior. Watch Carl Higbie every weekday on Newsmax.